And this matter is before the court today on multiple defense motions, including summary disposition regarding the standard of care, summary disposition regarding cause of death, and partial summary disposition regarding all diagnoses other than pneumonia. I think that's uh, uh, the total of it. Uh, So into this time, I would invite counsel to place your appearances on the record. We can begin with plaintiff.
Good afternoon, Your Honor. Albert Dibb on behalf of plaintiff.
Thank you, Mr. Dibb.
Yes,
Good
sir.
afternoon, Your Honor. Sarah Cherry on behalf of Dr. Affman and Certified Emergency Medicine Specialist.
Thank you, Ms. Cherry.
Good afternoon, Tyler Anderson on behalf of defendant Dr. Shane Menzies.
All right, very good. Thank you, Mr. Anderson. And I think, these are Menzies motions regarding the standard of care and also the cause of death. And then it's Dr. Affman's motion and certified emergency medicines partial motion, I think is probably a better way to state it. So, thinking this through, why don't I start out with you, Miss Cherry, since um, I think that might make the most sense. Well, I don't know. Do you think so, or do you think we ought to start with Dr. Menzies?
Thank you, Your Honor. I think we might want to start with Dr. Menzies' cause of death motion, as we've incorporated some of that into ours, and it might make sense to start with that if that's okay with you, Your Honor.
That will work for me. Is that acceptable as far as you're concerned, Mr. Dibb?
Oh, yes, sir. Thank you.
All right, very good. Let's go on cause of death first. Then, as I and then these are going to go to this is Mr. Anderson's motion as such, and I think the argument here is, gee, Judge, we only have one person who's willing to commit to a single cause of death, and that's the expert medical examiner, forensic pathologist, who thinks it was pneumonia. The others, though they identify multiple causes of death, aren't willing to ascribe any sort of certainty to any of the above. Is that fair?
Yeah, that's pretty close, Your Honor. That's fair. So specifically, we all know that the law requires expert testimony to prove causation, and here the plaintiff's amended complaint alleges a bunch of different causes of death in the alternative, but the death certificate in this case listed chronic ethanol abuse as the patient's cause of death, Mr. Rimmer's cause of death. And specifically, plaintiff disclosed three experts. Dr. Melville testified unambiguously in his deposition that any attempt to ascribe a single cause of death would be speculation. He says it's all speculation. Dr. Miller says the same thing. He says there's no way to ascertain what the cause of death was. And then Dr. Diaz says, I would have put pneumonia on the death certificate, but he also admitted, I'm not a clinician. I don't know how severe his pneumonia was. He doesn't even know if the pneumonia could have killed him based on the severity. And the records very clearly indicate this patient had normal oxygen saturations and was not looking like he was going to die of pneumonia or had any oxygen or pulmonary issues while in the ED. So that's sort of that's the basis for our position. And we added the alternative argument to the extent that the courts decided that, Dr. Diaz's testimony was enough to save the pneumonia piece of it, but there is absolutely no evidence or expert testimony regarding any other cause of death. So we filed this motion just so the jury was not permitted to guess or speculate as to how this patient died. That is plaintiff's burden to prove.
Okay. And, it seems that Mr. Dibb in his response is arguing, yeah, well, there was a diagnosis of pneumonia at the time. And that might be why Dr. Diaz came to the conclusion that, well, I would have listed pneumonia on the death certificate because that was what, those other medical conditions, including kind of the overarching chronic alcoholism, were, sort of at least identified, and preliminary tests indicated that there could be some issues. But it seems like pneumonia was the only diagnosis ascribed at the time that he came into the emergency room. Is that accurate?
Yes, that's accurate, Your Honor. And the other two key points to this issue is number one, plaintiff talks a lot about the various abnormal testing, and this patient had a medical history of abnormal testing. I mean, he had long-standing chronic kidney disease. He had uncontrolled hypertension. He was discharged from his cardiologist because he didn't go to appointments. I mean, basically, this patient had various medical issues and decided he did not want medical treatment for them for many years. And secondly, both the evidence from Dr. Affman's deposition, who Dr. Affman was the physician who talked to this patient directly during the time of discharge, and was the only physician who could have discharged or admitted the patient involved in this. And additionally, from Mr. Rimmer's significant other, Ms. Bailey, both testimony indicate he left the ED on his own accord, did not want to stay, did not want further testing, did not want to be in the hospital, did not want to go back to the emergency room after Miss Bailey took him or started taking him home, and then took him home eventually. So that would be sort of an intervening cause, clearly, as to all of plaintiff's claims, in addition to the fact that his experts cannot testify as to one more likely cause than any other.
Yeah, and I
So
definitely want to discuss the discharge decision, but I do kind of want to address it sequentially here. So if you
sure.
bear with me for a minute, you think now Affman he's part of the certified emergency specialist group?
Yeah, that's Miss Cherry's client, Dr.
Okay.
Affman, and that group.
But I think you're telling me that he had admitting privileges, i.e., in some cases, the ER docs and the group in general don't have privileges. You got to get a hook into, either, a personal care, primary care, or, obviously a specialty within the hospital to admit, but that's not the case here.
I don't know how it works. He might have had to contact one of the hospitalists. I'm personally not sure on that, but what I know is residents are not permitted to make a decision as to the final decision as to whether to discharge or admit a patient. They are not permitted to do that.
Yeah, certainly your client Menzies wasn't able to do it. You think, and you're not certain on Affman, and I will definitely follow you. You know it's coming, Miss Jerry. So hold that over in your mind for the moment. All right, moving on then on the, decision. What I'm going to refer to as a discharge decision here. It looks like there was some confusion regarding the forms used at time of discharge. Can you explain to me what, there was no AMA form filled out. It looks like the form that was filled out looks more like he voluntarily or, discharged with at least the blessing of someone in the ER. Is that different?
So Miss Cherry also might be able to expound on this some more, but my understanding of the testimony, and I think it's pretty clear, is Dr. Affman indicated he decided not to file the AMA paperwork and create that contentious relationship with the patient because number one, usually patients will not fill prescriptions if they're mad at the doctor or get that paperwork. And then number two is he also wanted the patient to come back. He added into the record the strict precautions for return. And, if he got into a contentious argument and discharged the patient AMA, he indicated that he was concerned the patient would not come back, even if he should have come back. So, I mean, it is what it is. He didn't say he was AMA, but again, I'll refer to not only the record, but the testimony of Dr. Affman and the testimony of Mr. Rimmer's significant other confirms Dr. Affman's testimony. She told him multiple times in the car and in the parking lot, like, we need to go back to the hospital. And he absolutely did not want to do that, which suggests to me that, he he left on his own accord and wanted nothing to do with any more medical care.
Okay. Yeah, no, and one can see that situation developing, and rather than, like you say, have it turn into a blow up and a contentious relationship, perhaps the doctor's trying to preserve what positives there might be there. And like you say, whether it's to increase the chance of follow-up care or increase the chance that he comes back to the ER, at some later date or later hour, if things worsen, he elects not to frame it as contentiously and allows them to discharge with instructions. Now, and I think that part of Mr. Dibbs' response here, and of course this is for Miss Cherry too on the standard of care issue, is, well, okay, we got a diagnosis of pneumonia, but let's be honest, this guy's got 3 or 4 other conditions that could kill him. In that light, why don't we admit on pneumonia and observe on all the others too, as this precaution, so that none of the others that might kill him, or at least if they're going to kill him, we'll at least see it coming better because he's in the hospital. Why shouldn't I look at that more larger constellation of symptoms and past issues that he had?
Can Your Honor, is it okay? Because we filed a joinder and concurrence. Can I address
I'm
part
going
of
to give
that
you a
as
chance,
well?
Mr. Chair. Let me give it to Mr. Anderson first,
Oh,
and then
sure.
Mr. Give
Sorry.
you a chance, and then finally I'll give Mr. Dibb a chance to fight against the overwhelming numbers.
So yeah, so with respect to the admission, frankly, from my client's perspective, Dr. Menzies couldn't have admitted this patient. Like he was not allowed to. So, I mean, I do think that falls squarely within Miss Cherry's purview. However, again, I think the pertinent point here is Dr. Effman testified that he wanted to do further testing. In fact, there was an EKG order entered, and maybe they planned to do that until Mr. Rimmer decided he wanted to leave, and then they canceled the order because he was leaving. So there's testimony in the record that suggests both Effman and Menzies wanted to keep the patient for further monitoring or at least perform other testing, and then the patient decided to leave. So from that standpoint, whether he should have been admitted is a little bit irrelevant because they couldn't have admitted him if he didn't want to be admitted, right?
Yes,
So
right. We normally, unless it's an involuntary admission in a mental hospital type state, we normally don't, in effect, lock a patient in a room and say you have to stay there. So
exactly. So from our standpoint, with Dr. Menzies, given his limited power to practice as a resident, he couldn't admit or discharge patients. That's our position on it. And like I said, I think Miss Cherry might have a more complete answer for you.
yeah, well, and just bouncing back quickly, I think one of the other, causes that Mr. Dibb brings against, perhaps the most compelling, given the circumstances here against Menzies, is that he, was in a position to more thoroughly document, a dire situation and failed to do that, and thus failing to inform the attending physician of what was going on. Is that a potential for basis as a liability, a sort of standard of care for a uh, whatever Menzies status was there, what do we call them when they're
A
a
resident
resident? Yeah,
earning
one of those
insurance.
things. It's getting late in the day here. All right.
Sure, understood. And my answer, very simply, is absolutely not, Your Honor, because Dr. Effman very clearly testified that he discussed Dr. Menzies' independent examination with him after Dr. Menzies saw the patient first, examined the patient. Then he went back to Dr. Effman and talked to him about his examination. Then Dr. Effman came in and did an independent examination and workup of the patient. So to the extent Dr. Menzies allegedly did not document something he was supposed to document, it had no impact on the care. Like Dr. Effman was aware of what was going on. They discussed the patient, and he wasn't relying on the documentation specifically to evaluate and treat this patient. So that would be my answer, is it has nothing to do with the outcome in this case.
Okay, all right, very good. Let me move to Ms. Cherry. I know you have several points you want to address.
Your Honor, we can start with all your questions if you want to, as it relates to the causation motion.
Yeah,
So,
well, actually, why don't we start with well, no, that's fine. We can go back. Yeah, why don't you go in the order you've got them?
okay, so for because we filed a joiner and concurrence in the causation motion because it's equally applicable to us. And Mr. Anderson covered a whole bunch of things I'm not going to repeat here, but starting with the issue of causation, even if this patient were admitted hypothetically,
Did your
plaintiffs
guy admit? Did he have Dr. Affman? Did he have admitting privileges?
well, I guess I want to make sure we're using the same language here. He can call the hospitalists or internal medicine physicians to say, I think this patient needs to be admitted.
Yeah, take a look at this guy. He
admission.
looks like a good admission candidate,
Right.
but he can't sign off and admit and check the guy into a room at Metro.
Correct. That's
Okay.
correct.
Yeah, I mean, that's my understanding usually of how those ER docs operate, though I'm aware it could be different. So, okay. All right.
Yep.
So, I mean, he couldn't admit. What he could do is he could hold for further observation while he is in communication with hospitalists and other folks at Metro, pulmonologists or whoever you might want to talk to, and perhaps one of those folks, after speaking with them, particularly if he advocated for admission, might decide to admit, but he wouldn't ultimately be the one signing off on admission.
Correct. Correct.
Okay.
And then, the other issue here is what you very aptly acknowledge, which is as the emergency medicine physicians, they can't make a patient stay. And so Dr. Affman discussed this very thoroughly in his deposition. Dr. Affman actually remembered this patient, and he had a very vivid memory of this patient for a couple of reasons, but he very specifically said, for the reasons that you acknowledge, we don't want the relationship to be contentious because we want to make sure patients can return, and AMA is a very contentious issue. This patient would not have been able to receive the script for the medication for pneumonia if he had to sign out AMA. So Dr. Affman said, instead of having him sign AMA papers, I want to make sure that I'm able to actually give him a script for the medication for pneumonia. And he has instructions that I wouldn't be able to give him if he signed out AMA, saying, this is why you need to return. This is what I need you to do for follow-up. I need you to see somebody outside of this emergency room.
And to clarify, you said give him the script. Do you mean he's walking out with the old prescription card note in hand, or he's had a couple of doses and he's walking out with antibiotics in hand?
No, a script, and I guess whether it's in hand or sent to the pharmacy.
Yeah. I
But
guess
yes,
the old
an
days
actual
we used to.
prescription for the medication, not medication in hand. But he
Right.
wouldn't be able to get that prescription to go pick up if he was AMA.
Okay. And could the doctor, since he did diagnose pneumonia, could he have given an initial dose of antibiotic right there in the emergency room?
It's possible, and I don't want to speak for
Yeah.
an emergency medicine physician. I think that's possible, depending on what else would have developed in that emergency room visit had he stayed longer.
Sure.
But a really important point is plaintiffs' experts have never established, ever, not once, have said that if he were admitted to the hospital, more likely than not, he would have survived. And so we asked plaintiffs' experts about the statistics as it relates to in-hospital cardiac arrest and potential death at that time. And they weren't able to rebut the statistics. I know it really didn't come to light as it relates to this motion, because I think their testimony is so clear in terms of their testimony of Melville and Miller not being able to prove more likely than not cause of death, and Dr. Diaz having his opinions about it being pneumonia. But the statistics are that plaintiffs' experts, again, never rebutted, is that 25% or less of patients that suffer from a cardiac arrest, which is what would have happened if he, let's say, hypothetically died from pneumonia, only 25% or less in hospital arrest survive.
So that
And
gives you the
so-
great argument to make in front of the jury. Folks, even if we missed it, he would have died anyway.
I get it. But plaintiff's expert still has never been able to say if he were admitted to the hospital, he would have survived. So, because you address the litany of issues that the plaintiff's experts brought up as well, but they don't even overcome that issue either. And so for those reasons, and all the reasons that Mr. Anderson stated in the briefing, plaintiff has not established that this patient would have survived even if the patient were admitted. And then it goes to the issue also of the cause of death, which Mr. Anderson also addressed.
Of course, they don't have to establish that he would have survived. They just have to establish that there's an argument that more than likely than not he would have survived to fight another day had he stayed in the hospital. And I think it's probably self-evident to myself and most jurors that one, regardless of their alcoholic condition, probably has a much better chance lying in a hospital bed with nurses and monitors hooked up to you and regular checks, and you do going home and crashing on the couch with none of those things. In that, you know, I think that's probably, and I think that one's a hard one to argue that you don't have a better chance of survival in the hospital of dying of a medical condition anyway than you do outside the hospital. So. Yeah, I get what you're saying though, is that right? When we derive down to the nitty gritty here, which is really the key thing, you know, any of these conditions, well, and I think is also, you know, and I guess that goes to my final question to Mr. Anderson was, okay, I've got you know, an arguable hook to advocate for this guy's admission, that is the pneumonia diagnosis, although not everyone that goes to the hospital with pneumonia obviously gets admitted. In fact, you know, I'd say probably a lot of people get sent home with pneumonia and you know, start an antibiotic and, you know, follow up with your primary care. Kind of what happened here, but you know, this isn't just pneumonia. This is pneumonia plus the constellation of other life-threatening conditions. You know, that, you know, should I allow at least standard of care testimony to come in, you know, as to, boy, they should have looked at, you know, not just a single, you know, threat, but the global picture on an overall standard of care with regard specifically to your client, Affman.
Yeah, Your Honor, and to address that, I guess I want to start with this, which the undisputed facts are the death certificate lists chronic ethanol abuse as the only cause of death. Plaintiff's expert Melville said that he could not list a cause of death, more likely than not due to incomplete information, and said otherwise he would be speculating. Miller said he could not say any of the conditions more likely than not caused his death, and Diaz testified pneumonia more likely than not caused his patient's death. Plaintiff has not and cannot rebut any of those facts. And so there's also the undisputed law that we put in our response in our reply brief: Wamers, Pennington, Craig, Teal, Gezi, Dykes, Thomas, and Skinner. Every single one of those cases supports the defendant's position that plaintiff has to establish proximate cause beyond mere speculation and more likely than not for expert testimony. But plaintiff cannot rebut that, and they can't rebut, and they did not rebut in their response that there was any case law that goes against the case law that we mentioned. In fact, a thorough reading in Skinner deals with situations very similar to this case. The Michigan Supreme Court in that case was abundantly.
You're talking about Skinner versus Square D?
Oh, I apologize.
And your volume just went down for an unknown reason. It could be me, could be you, it could be the working of the interwebs, but I lost your volume for a bit there. Ms. Chair, you may continue.
Apologize about that. So plaintiff has not and cannot rebut the testimony and the application of the case law that we cite, that litany of cases. And a thorough and complete reading of Skinner deals with these exact situations, which is in our motion, that plaintiff has to connect the standard of care claims to the proximate cause more likely than not testimony. So to let in that litany of other causes not connect in any way to causation testimony would be going against all of these cases. So Skinner said, to be adequate, a plaintiff's circumstantial proof must facilitate reasonable inference of causation, not mere speculation. And they go on to say that And they're
just to
quoting
pause
them.
you, Diaz says it was pneumonia. Granted, he's the pathologist. He doesn't have
Right.
anything to say about the clinical care,
Right.
but he does say, well, the death was pneumonia. So plaintiff says, well, that was that was the criteria right there to advocate for at least continued observation, potential admission, and then, and particularly because, this is a complex case. This guy's got a lot going on else, in addition to, it's not just a pneumonia, in other words, but the pneumonia plus is enough to admit him. But you're saying that doesn't reach that Skinner standard.
It doesn't reach the Skinner standard. It doesn't reach the Waymer standard, Pennington, Craig, Teal, Gazy, Dykes, Thomas. And so, I mean, plaintiffs, other experts all had a chance to provide causation testimony, but they couldn't do it. And so again, it just doesn't reach that standard. And even the Kaminsky case cited in Skinner, they specifically talk about this issue and they say, a theory of causation, a conjecture is simply an explanation consistent with known facts or conditions, but not deducible from them as a reasonable inference. So they even say there may be two or more plausible explanations as to how an event happened or what it produced, yet if the evidence is without selective application to any one of them, they remain conjecture only. And so going on, that case essentially says, however, a basis is only slight evidence is not enough, nor is it sufficient to submit a causation theory that, while factually supported, is at best just impossible as another theory. Rather, the plaintiff must present substantial evidence from which a jury may conclude that more likely than not, but for the defendant's conduct, the plaintiff's injuries would not have occurred. So to be able to permit a jury to hear testimony on other causes of death or the other issues of standard of care that were brought up by plaintiff's expert goes against these cases. Why do they need to hear allegations of standard of care that have zero support for proximate cause? It doesn't fit with these cases, and it shouldn't be impertinent from a jury. So we've again concurred in the motion for proximate cause. We agree they haven't had enough to establish pneumonia as the cause of death. But if that testimony is going to be allowed, the only standard of care allegations that should be permitted to go forward are only the ones related to pneumonia, which are numbers 6 and 7 of plaintiff's allegations, and all the other standard of care allegations have nothing to do with proximate cause and therefore should not be presented in front of a jury. Thank you.
All right. No, thank you. Well, let me hear from Mr. Dibb after your, as I said, you're outnumbered, Mr. Dibb, but I feel confident you can hold your own here. Let's start with pneumonia and Dr. Diaz. This guy's the pathologist. He didn't
Right.
Do an autopsy. Isn't he kind of just guessing at pneumonia?
Give me just 1 second, Your Honor. So, we're going to take the pneumonia one first.
Yeah.
Sir?
Well, I'm just kind of going backwards.
Okay.
with
Yeah,
what
no,
I heard
that's fine.
recently. My brain works better that way for some reason.
Understood. I could not disagree with the defendants more. The medicine in this case is multifactorial, and the causation testimony is multifactorial. The death occurred within hours of discharge, and this was after Mr. Rimmer presented with multiple acute, dangerous abnormalities, any one of which threatened, according to the expert testimony, any one of which is his conditions could seriously threaten his health and cause death. Now, this motion on the pneumonia is it turns on one premise. Because Dr. Diaz identified pneumonia as the probable immediate cause of death, defendants are claiming that all non-pneumonia standard of care violations become legally irrelevant, but that's not the law in Michigan. And in fact, it's not the record that has been established in this case. Plaintiff isn't claiming that there are 8 disconnected injuries. Plaintiff is claiming that there's one fatal negligent discharge of a patient who presented with multifocal pneumonia, with sepsis, SIRS indicators, tachycardia, hypoxia, severe anemia, GI bleeding, hypokalemia, acute kidney injury, cardiomegaly and edema, and possible heart failure. The non-pneumonia criticisms are not extra claims, right? They explain why Mr. Rimmer was unstable and why discharge in this case was unsafe, and why admission was required. And
Sounds like you disagree
inpatient,
with the defendant's argument that in a medical malpractice, specifically wrongful death case, that a cause of death needs to be, established, that you think one could proceed on multiple potential causes of death, all possible, but none more likely than the other.
well, not quite, Your Honor. What I would submit to the court is you have many conditions in this case which are contributory to the cause of death. And that is certainly admissible. The defendants want to turn this immediate cause into exclusive cause, right? But Dr. Diaz did not say that pneumonia excluded the other conditions. All he said was pneumonia was the probable immediate cause, and that anemia, GI bleeding, electrolyte imbalance, hypokalemia, acute kidney injury, possible congestive heart failure, and in fact, he tossed in chronic alcohol abuse were contributing factors. And that certainly is admissible expert testimony that should be given to the jury. Now, counsel distorts Dr. Melville's testimony. Dr. Melville is the emergency medicine expert who connects the emergency medicine breaches to the unsafe discharge. And he identified multiple breaches by the defendant Athman, including the failure to appreciate how sick Mr. Rimmer was, including his failure to appreciate the sepsis and the SIRS, his failure to recognize the hemoptysis, the failure to work up chest pain, tachycardia, acute kidney injury, failure to administer IV antibiotics, failure to evaluate for Legionella, failure to document AMA refusal. So these opinions are causally relevant because they all go to the same clinical question. Should this patient have been admitted and treated or discharged home? His testimony, Dr. Melville's testimony, supports the proposition that Mr. Rimmer did in fact meet the sepsis SIRS criteria, that he was unstable, that he should have been admitted, and would have survived with appropriate inpatient treatment. And we attached those portions of, well, we attached the entire deposition testimony of Dr. Melville that supports that proposition. That goes contrary, directly contrary to the representation made by counsel that there is no testimony that appropriate inpatient treatment would have made a difference. That is contrary to the facts in this case. In fact, there is no expert testimony to contradict the plaintiff's expert's testimony. Zero. So what they're trying to do is distort and parse out the plaintiff's expert's testimony, but that is a adventure that is unsuccessful because they in fact do support plaintiff's case. Dr. Miller connects the non-pneumonia conditions to proximate cause. He in fact testified, contrary to what counsel stated in the record, he testified that Mr. Rimmer's death was multifactorial and in fact involved all of these conditions, which I don't want to keep repeating, but all of the conditions, including the pneumonia, the hypokalemia, the GI bleeding, et cetera. Dr. Miller did not merely list possibilities. He testified that more proximate causes of death were the untreated pneumonia, the untreated hypokalemia, and the unaddressed anemia. And he further testified that admission would have allowed treatment of the pneumonia and all these other conditions and problems, and that more likely than not, Mr. Rimmer would have survived had he been admitted and treated. So this representation by counsel that Dr. Miller or that plaintiff's experts did not testify to such is completely wrong and false.
Well,
The
let me move
testimony-
to that discharge because that's a key part of this, I think, as well. Now, one of the faults is again a failure to document the AMA refusal. It struck me as a strange thing to argue as a plaintiff because you're saying, well, if my guy indeed did refuse medical care against medical advice and walked out, you should have documented it better. It seems like a kind of unwinnable plaintiff's argument, and that you're saying my guy did want to walk out and refuse this care, and that the least you should have done was use the proper form and say it was against medical advice, which didn't happen here. The form that got filled out looks like, if you look at the form, like this was everyone agreed that this was the time for discharge, and it's time to go, and by the way, here's your prescription. Go down to Rite Aid and pick it up and start taking the antibiotics rather than giving a first dose or starting those out right at the ER. How do you deal with that overarching situation of what's a doc to do? When the doc says in this case, I wanted to keep him for further observation, but for whatever reason, he didn't want to stay. His partner says he didn't want to stay, seemingly backing him up, and nonetheless he goes. It didn't, obviously the doctor's not going to handcuff him to the bed. What else is he supposed to do?
For the life of me, I cannot see where and how this argument has been made by defendants that Mr. Rimmer walked out. In fact, the record is completely to the opposite. The defendants repeatedly suggest that he chose to leave and refused further care, but the contemporaneous chart says nothing like that. In fact, it says just the opposite. It's undisputed that the chart states in plain language, quote unquote, that Mr. Rimmer was, quote, agreeable to discharge. Now, what does
we
that
suggested it and he agreed to it?
The defendants are suggesting discharge with this plan or these discharge instructions, and the record states clearly that Mr. Rimmer is, quote unquote, agreeable to discharge. There's no AMA form. There's no documented refusal of admission. There's no documented refusal of further testing. There's no elopement notation. Sure, they're claiming after the fact, years later, that he has a memory that he didn't want to upset Mr. Rimmer by giving him an AMA form. That's fine. But Mr. Rimmer doesn't need to know about any notations that the doctors make in the record that this patient eloped or this patient refused admission or this patient wanted to leave against medical advice. The doctor could have easily, if that happened, that's a very important, that is such a significant medical event for a patient to leave against medical advice, that to think that that happened in this case and it wasn't documented, I mean, that is
Raises questions itself.
It's just unbelievable. So unbelievable that a jury should be allowed to decide this. Now, Athman says that he chose not to label the discharge AMA because he was concerned it would make the interaction worse. But that testimony creates a fact credibility dispute. It doesn't establish an undisputed refusal as a matter of law. They're asking the court to dismiss these the causation, the standard of care, the non-pneumonia claims as a matter of law that there are no disputes to the facts of this case, and nothing could be further from the truth. If this was truly a refusal of recommended observation or admission, the standard of care required documentation of that refusal. And the record is devoid, and it says just the opposite, that they suggested discharge and that Mr. Rimmer was agreeable to discharge. Should I address the causation and the?
Yeah, please do, Mr. Dim.
Okay.
Yeah, and I guess what I'm struggling with on causation is, the core, of course, of medical malpractice is it's much more specific than a negligence claim, for example, that says, well, you didn't behave like a reasonable person. It forces the plaintiff and shifts the burden, at a fairly early point of the case, right at this point, to say, you've got to show there's a more likelihood of not. Why'd he die? And what
Right.
breach of standard of care killed him? And
Yes, sir.
I think I'm hearing the argument is here, folks, that, we're stapling together two unrelated experts, granted, but if we do that, we can say he died of pneumonia and the standard of care wasn't, you could have admitted him and or not admitted him, but you could have observed him longer with IV antibiotics, and maybe, some other hospitalist or someone would have admitted him after further evaluation, and we wouldn't be here today. That's one line that I think, a reading of at least Ms. Cherry's brief could lead me down. Why isn't that the correct path if I narrow this claim down?
I think with all due respect to counsel and to the court, I think the correct path is to follow the undisputed expert testimony in this case that, yes, pneumonia was more than 50% likely the immediate cause of death, and that severe anemia, GI bleeding, hypokalemia, renal dysfunction, and these other abnormalities, all of which, by the way, Your Honor, were objectively documented through diagnostic testing, X-rays, lab results, and other diagnostic tools that were used. None of this is subjective. All of these conditions, the GI bleeding, the hypokalemia, the kidney dysfunction, all of these things were objectively documented in the emergency department. So that's the path that we should be following, that pneumonia was the immediate cause of death, but these other conditions certainly contributed to that fatal deterioration. So defendant argues that plaintiff cannot prove the cause of death because the death certificate says alcohol abuse, but there was no autopsy performed. And it's interesting because defendant's own cause of death theory is also formed without an autopsy and without any expert support. The absence of an autopsy is not a one-way street, right? It affects weight and precision, but it doesn't make the defendant's theory conclusive or the plaintiff's expert
It's just a
testimony
piece of evidence.
speculative
Right.
as a matter of law. Defendants want to characterize plaintiff's causation theory as a litany, quote unquote, of unsupported alternative ailments. Well, that's not true. These are completely supported in the medical record. They're documented objective abnormalities from the emergency department. The pneumonia, the low hemoglobin, the positive fecal occult blood, the low potassium, the leukocytosis, the tachycardia, the renal dysfunction, the cardiomegaly, the edema, the tachypnea, all objectively documented. And plaintiff's experts' opinions are not left to speculation. We're not asking the jury to guess in this case, Your Honor. Plaintiff would be asking the jury to decide between, well, we haven't heard the other experts' views because none have been advanced or supported in this motion. But if they were, it would create a question of fact, right? So You know, Dr. Diaz, there's a lot of emphasis on Dr. Diaz's testimony, but his testimony alone creates a genuine issue of fact in our estimation. You know, he's a board certified forensic pathologist. He's the chief medical examiner in Washington, D.C. And
Well, he's not
his,
going too far out on a limb here. He's saying, I got a
no,
diagnosis of pneumonia.
right.
Guy we know
And I
has
think that's,
pneumonia and didn't get treated. I think he died of pneumonia. I
yeah,
mean, I
correct.
wouldn't say Dr. Diaz has any worse basis to, come to that. Now, Diaz only looked at the ER records, correct? He didn't look at the, supposedly, although I don't know, since this guy admittedly hadn't treated in 3 or 4 years prior, I don't know where Start got this, wealth of medical records.
Well, I'm here to tell you, you'll never hear from Start because Start wasn't identified as an expert by the defendant.
Okay.
As I pointed out in my response to the motion, they attached this ad hoc affidavit that from Dr. Start, but that if the rule, the summary disposition rule is if you can't if the substance of the affidavit is not admissible, then the content of that affidavit is not admissible, and Start was not identified by defendant as an expert witness. So I don't think we'll ever hear any contrary expert testimony from the defendants. Otherwise, we'd see it in this motion. I think that if we take Dr. Miller's testimony, he's the hospitalist. He explained the clinical progression of what happened here. He testified that Mr. Miller had this multifocal pneumonia and all these other conditions. And the defendants are focusing on this part of Dr. Miller's testimony that he could not assign a percentage to each individual condition, right? But I would submit to the court, this is not fatal. His testimony was that the death was multifactorial and that one or more or all of these conditions caused death, and testified that, and again, when I hear these representations on the record that there's no expert testimony, he did testify that inpatient admission treatment would have included a number of things, all of which, had that been done, more likely than not, would have altered and changed the outcome in this case, and Mr. Rimmer would not have died. Dr. Melville, again, he's the emergency medicine expert. He identified medically valid mechanisms of death: septic shock, anemia-related cardiac compromise, the fatal dysrhythmia that was triggered by his infection, the severe anemia, the hypokalemia. I mean, this is a repeated theme in this case, that this was a very, very sick man when he was in the emergency department, and the defendants, put him out on the street without adequately treating him and giving him the deserved treatment that this man needed to save his life.
They put him out on the street, or he walked out on the street, and I think that's one of the key fact questions that a jury, might examine in this matter. Let me go back and have you start where I finished, and that was
Yes,
with
sir.
Mr. Anderson and Menzies, the
Standard of care issues.
yeah, and why is he still even in the case? I mean, typically these residents, they're not supposed to, utter a breath or say a word without supervision and oversight and approval from the attending. Why is he even still in the case?
Because he is another defender that could have prevented the outcome in this case, Your Honor. Even though Dr. Affman, the defendant, may have had the final authority over discharge or the recommendation for admission, that we don't dispute that. But the final authority by the attending does not erase this resident's own duty to perform the assigned resident's functions with reasonable care. And he's not a bystander. Dr. Mendes isn't there just whistling down the hospital hallway. I mean, the record shows that he personally participated in the care, that he entered orders, that he authored portions of the clinical record, that he generated the discharge materials, and that he in fact participated in the evaluation leading to discharge. The question is not whether the defendant Mendes could have independently admitted the patient. No, that's not the question in this case. The question is whether he reasonably performed the tasks that he undertook in ordering, documenting, interpreting, communicating, and participating in Mr. Rimmer's discharge. Now, Dr. Melville, who is the emergency medicine standard of care expert, in fact, identified specific breaches attributable to Dr. Mendes.
I saw those, but I thought the only one that carries any weight, even given what you're saying there, because the Affman, the physician says, well, I approved of everything Menzies did. And I guess the only one that I think possibly keeps him in here is, gee, had he written more, communicated more, given me more information, maybe it would have influenced Affman's decision differently. But Affman doesn't say that. He doesn't say, I wish I'd have had a little bit more from Menzies or anything like that. I think your expert saying, well, an ideal Menzies, the world's best Menzies might have, given a AI like workup to Affman, but nonetheless, is that really enough to keep him in the case?
Well, but I think a careful reading of Dr. Melville's testimony demonstrates that he believed that the defendant Mendes committed multiple breaches, which all contributed to this man's inappropriate discharge. First, there was a clinically invalid orthostatic vital sign assessment in Mr. Rimmer, who was already tachycardic. Menzies didn't order orthostatics properly. He didn't order, and then he did order, and then he canceled an EKG without documenting any explanation as to why. And this is despite the fact that Mr. Rimmer was complaining of chest discomfort and had tachycardia and had objectively demonstrated on X-ray cardiomegaly, had severe anemia by laboratory testing and hypokalemia. Why Menzies ordered an EKG, this is Menzies who did this, why Menzies ordered an EKG and then canceled it without any explanation, that's a violation of standard of care. And, there are others. There was a blood in the stool.
Yeah, blood in the stool, right.
And he didn't adequately describe that or tested that. There was also very little documentation from Menzies concerning these various critical abnormalities, and no communication with the attending, as you pointed out, Your Honor. That's
really the key, is that
is.
Yeah, that's the only way Menzies can act anyways, is he's got to communicate this wealth of information to Affman, and then Affman ultimately makes the call. And I think what you're saying is, it's one thing to say, well, this is a learning experience, and if Affman falls Menzies short, then he uses a learning experience to explain to him where his documentation and things like that could have been better. But that's easy to say, when these guys are all wearing white lab coats and attending to people in the emergency room. They all have to, pull their weight, in effect.
Yes, sir. And I want to point out too that this orthostatic vital sign breach committed by Menzies is not a minor thing. The defendants minimize this orthostatic issue, but it mattered in this case because the emergency department note relied on the orthostatic vital signs to justify no transfusion and discharge. So the orthostatic order itself called for orthostatic vital signs after a fluid bolus, but there's no documented therapeutic fluid bolus that was prescribed before those orthostatics were used. So the chart
Maybe has some inaccuracies and other issues going with it as well.
I mean, a jury, yes, Your Honor, a jury could easily find that Menzies relied on an incomplete or an invalid orthostatic process to minimize the significance of his profound anemia. That was, I mean, it was a magnificent anemia and GI blood loss.
I haven't heard it described as magnificent before.
Well, you can say profound would be.
Yeah, I think profound, or yeah, I know what you're trying to get at.
Yeah,
Mr.
I already talked about the EKG.
Noticeable.
Yes,
Yeah.
sir. And the hemocult. Right.
I want to give defense counsel just kind of a moment last. And my question for you, Mr. Anderson, is there a standard of care for a resident like your client, Menzies here, or is he so subsumed by the standard of care of the ER doc, which is, I think, what you're telling me, that I can't evaluate him separately, and it really is the ER doc standard of care?
Well, in general, there is a standard of care to residents, no doubt. But here, as plaintiff's counsel just admitted, this is all one claim, and the claim is the patient shouldn't have been discharged, and Dr. Menzies can't make that decision. So that's essentially what we're getting at here, is that regardless of what they say he should have documented, or if he should have described the stool with as burnt orange instead of however he described it, and if he should have done a different way of orthostatic vital signs, he can't make the decision of whether the patient gets admitted or discharged. So that's essentially the argument here with respect to
the physician's decision, but he, of course, is not going to ever make an independent decision of that magnitude. He can order a test and interpret the test, but again, he always knows that's going to also be reviewed by the attending.
Correct. And like we said, Dr. Affman testified that he independently examined the patient. He's the one that talked to the patient right before discharge. He recalled that conversation, as Ms. Cherry referenced earlier. So, I mean, our position is there's nothing Dr. Menzies could have done to keep the patient in the hospital, or there's nothing that he
could have ordered.
Yes, exactly, under the standard of care.
And just like Affman, he could have grabbed the patient by the hand and said, "You're not going anywhere, buddy," and they could have gotten into a struggle there, but that wouldn't have been very probably advisable for a whole lot of reasons. So, all right, Ms. Cherry, any saved comments before I don't want to leave you out?
Yes, Your Honor, and I appreciate that. Just a couple notes on, and I don't want to go over and over the same things, but I want to go back to a couple points. Mr. Dibb mentioned a number of times about all these other things, and I want to go back to what I was talking about. There's no dispute about plaintiff's expert's testimony about the no absence of more likely than not testimony except for Dr. Diaz. And again, plaintiff cannot dispute any of the facts. Kind of to your question earlier, Your Honor, is you said, why should I not follow the case law that's set forth in defendant's motion as it relates to proximate cause and connecting the proximate cause with the standard of care? As you noted, plaintiff never raised a single case, either in his brief or now, that disputes any of the case law and what is mandated by the Supreme Court and the Court of Appeals, which the court needs to follow as it relates to connecting the proximate cause testimony more likely than not with standard of care claims. Plaintiff's counsel also noted that Dr. Start is not providing expert testimony. That's not true at all. He's listed on our witness list as providing expert testimony, Your Honor. We've indicated it with an asterisk, and the asterisk says treaters that are provided with this asterisk will provide expert testimony at the time of trial. Plaintiff has the burden of proof here. And again, he keeps talking about defendants have not proffered any expert testimony. He hasn't taken the depositions of our experts. We've offered them. He hasn't taken them. He doesn't want them. So, it doesn't really matter as it relates to these motions because the plaintiff has the burden of proof, which you've pointed out. Mr.
And what you're pointing to are inconclusiveness and deficiencies in his expert testimony. You're not saying I need my expert testimony and we're creating a the proverbial battle of experts here, you're saying his expert testimony, even taken in the light most favorable, simply not enough.
Correct. That's exactly what I'm saying. You just said it more eloquently than I could.
Good. All right. Well, that's a good point to conclude on. I think I've understood all the parties' position, and this, like all medical malpractice cases, is a complicated case. And of course, what's not very complicated is at the end of the day, a malpractice case hinges upon allegations that medical professionals, in whatever role they're in, breached an applicable standard of care vis-a-vis a particular patient. And that burden does rest with the plaintiff to establish what the standard of care was breached and the cause of the breach of the standard of care causing the harm, or in this case, the death, allegedly, of the plaintiff, in this case, who is Mr. Rimmer. And first of all, I think I need to address the question of the resident. And I have to agree with the defendant in this case regarding the resident, in that a first-year resident like Dr. Menzies is in the ER. He is wearing a white coat and looks, he's often, usually I think referred to as doctor, but we all know that they're in training. They don't have the ability to act or decide on diagnoses, admission decisions, what I'm going to refer to as making decisions, final decisions regarding critical elements of a patient's care. Can they order additional testing? Certainly. Can they interpret that testing and pass that interpretation up to the attending physician? Absolutely, they can. However, they don't have the ability, under the normal understanding of the role of residency itself, to make any of those final decisions. And at the end of the day here, the decision, as I'll explain a little later in this opinion, that, might have kept Mr. Rimmer alive was a decision to retain him, perhaps with some convincing to retain him. Of what sort, I don't know what that would have looked like, and I think that's part of the jury question here, in the emergency room, in the hopes that he would be admitted, certainly on the diagnosis of pneumonia, which, as I'm going to explain later, though perhaps not, immediately appearing that it was going to be fatal within the next couple of hours, certainly is a condition, when considered in conjunction with his other health conditions, that a jury could make a reasonable inference should have led to his continued observation in the emergency room and perhaps ultimate admission to the hospital, although we never know here if he ultimately would have been admitted. As Dr. Affman doesn't have that authority, someone else would have to write an order of admission. And of course, the final piece of that would be whether or not Mr. Rimmer would consent to admission, because I think there's going to be a strong argument made eventually in front of a jury in this matter that Mr. Rimmer wasn't going to go along with what any of these medical professionals said. He had had enough medical treatment at that point, having not sought very much apparently in the years preceding this emergency room visit, and just wanted to go home, for whatever reason, and no one was going to change his mind in that regard. And I think that does present a fact question for the jury as to what happened there at the emergency room that day. And unquestionably, and no jury is also going to believe that the standard of care required any of the medical personnel to grab Mr. Rimmer by his wrist and padlock that wrist to the hospital bed and say, buddy, you're staying here and we're going to watch you because you're too sick to go home. That's just not how our hospital admission system works. Of course, medical care is voluntary and ultimately in the control of the patient who's receiving the treatment. It's not, the doctor who makes the final call. We do rely upon the consent of the patients to receive the treatment. And I think there's an argument here that Mr. Rimmer, terminated his consent at some point, whether that was in his best interest or not. And for that matter, I guess, how that related with the medical advice he'd been given to date in the ER, how he had the tools to weigh that decision if he made it. So in any case, Dr. Menzies, though he might have talked to, Mr. Rimmer more, he certainly might have put more explanations into his notes. and painted a clearer picture, as it were, for the attending physician, Dr. Effman. I think that simply there just simply isn't, because he had no role in either the diagnoses. He couldn't make that final diagnosis of pneumonia, nor could he make the final decision to retain and observe uh, uh, Mr. Rimmer for longer in the emergency room. There simply is no possibility that he, breached even an internist standard of care, or caused, ultimately, arguably, the demise of Mr. Rimmer. So the motion with regard to Dr. Menzies being dismissed at this time is granted. Now, moving on to the partial motion for summary disposition, or it's a full motion for summary disposition, or in the alternative, a partial motion regarding pneumonia. And I think probably Ms. Cherry can sense where I'm going with this at this point, is that I would agree the uncertainty regarding the other potential causes of death that was testified, because both Melville and that other expert, not Diaz, not the pathologist, the your hospitalist,
Dr.
Mr.
Miller,
Dip-
Dr.
Miller.
Miller.
Yeah, they both list numerous serious medical conditions that afflict Mr. Rimmer and that were detected by testing in the ER and might have killed Mr. Miller. However, the jury can't speculate on which one of those killed him. And I think really the standard of care being asked upon here is, the standard of care is one that you simply should have observed this patient for longer to figure out what was going on. And you knew something was going on, i.e., the pneumonia, that could have certainly justified, and arguably in this case would have justified admission, because it has to be considered in conjunction with his multiple other medical conditions, would have justified continued observation, potentially oral IV dose right there in the ER, or potentially IV antibiotics if he was ultimately given an IV when he was being observed there, in order to get that IV process started to fight the infection, causing pneumonia. And of course, there's also the, Mr. Dibb mentions aside the Legionella pneumonia. I didn't see any evidence that this guy had, the dreaded Legionnaire's disease, but that evaluation could have been done down the road as well, and should have been, given the fact, again, that this gentleman, even though pneumonia may not be a severe diagnosis for the proverbial man on the street, for this guy, if he has something as serious and chronic as pneumonia, in conjunction with everything else, well, we want to keep him longer for observation. So I am going to find that the counts to proceed on are those pointed to in the brief here: failure to administer IV antibiotics for pneumonia, failure to evaluate the patient for Legionella pneumonia, and then also the failure to retain the patient here in the ER, or to more effectively convince the patient, as it were, to stay in the ER for further observation. I really think that's the hinge issue in this case at trial, is when he left, was it, because there are also certainly cases that the courts observed where people become so obnoxious in the emergency room's eager to get rid of them, and all of a sudden, might be against medical advice in some conditions. And this, I note, I preside over our mental health court, and unfortunately I see it with a number of my own folks. They aren't making sense. They're disruptive in there, and all of a sudden the docs come to the conclusion that, hey, it is time to discharge, whether it's against AMA or not, and tell them to follow up with another treater, simply because they're disrupting the function of what's going on. Now, that wasn't testified to. He may have been the only patient in the ER at the time. We don't know those things, but certainly imaginable, in a scenario here where the physicians in effect throw up their hands and say, I'd love to treat you more. And there was, I believe, some conflict that, Dr. Effman, makes the unsurprising suggestion that maybe cutting back on alcohol would help you a little bit. And Mr. Rimmer, unsurprisingly, was not happy to hear that. Totally, again, situations that are going to be within the everyday experience and knowledge of many jurors, and they will, be able to evaluate that, whether or not, how that decision came about, that he left the hospital without staying for further observation, because of course, if he had stayed for further observation and testing, well, then, another battery of tests would doubtless have been run on him upon admission based on the workup done in the ER and the deficiencies found. And of course, whatever operative mechanism killed him in the end. And, we do have the opinion of at least one uh, uh, pathologist, that is Dr. Diaz, that it was the pneumonia that ultimately caused his death, based on a review of solely the ER record. And after all, that was the only diagnosis he had, and certainly could pneumonia in conjunction with everything else be the primary cause of death. I don't think that, again, flies in the face of all common sense and, general knowledge, and that pneumonia can kill you. The sepsis and other things that can go with pneumonia can also kill you. And if you're in poor condition, like a 95-year-old patient with pneumonia, is obviously a whole different case than a healthy 16-year-old, who might do with just a couple days home from school and, of course, antibiotics and get better. The 95-year-old may have to be admitted to the hospital because of, other systemic things that are concerns. And I think that's the bottom line here, is that, with all those systemic concerns, there could have been a retention, a further observation period. And had that happened, I do think, again, certainly fair to argue to the jury, but arguable to the jury at a trial, that the outcome might have been different, because again, commonsensically, one is much better off in the hospital, hooked up to all those irritating machines, and having that nurse come in every 20 minutes to check your blood pressure and your blood oxygenation and all that stuff that they also monitor at the nurse's station and the Starship Enterprise like screens they have up in front of them there. And you're safer there. So, and you have alarms and things like that hooked up to you if something befalls you, or something drops below where it's supposed to be, or your heart stops beating. By golly, they come and at least give up their best shot at resuscitating you in that medical environment. So again, I think that does present the requisite, question of fact to proceed. I think the only thing, anyone's testified he was diagnosed with and could have been a prolonged observation on at the time was the pneumonia, although again, that's considered in light of everything else going on. So I'm not going to say that those other experts have to be excluded. They, can testify that, he had these other conditions, and those other conditions ought to be taken seriously. However, I think that the only one that could have, because the only diagnosis they had at the time was the pneumonia diagnosis. So that's what I'm going to allow the case to proceed on at this time. So I think I'm going to need a order from you, Mr. Anderson, getting Menzies out of there, and then I'm going to need an order for you, Miss Cherry, trying to make sense of what I said in the last 20 minutes here.
Can I clarify?
Sound better. Yeah, go ahead.
Okay, because I think what I heard you say is the plaintiff's counts number 1 through 5 are dismissed with prejudice, and plaintiff's experts are precluded from talking about those as standard of care allegations to a jury, but plaintiff can proceed on 6, 7, and 8.
And 6 is failure to administer IV antibiotics. 7 is evaluate the patient for Legionella pneumonia. And 8 is failure to indicate in the medical record the patient left the hospital against the medical advice. That again, 8 is not a great one in my estimation. However, I think there, that final claim is going to be failure to advocate to the patient to retain him in the hospital for further observation, or adequately advocate because he left. So, and it appears at the end of the day that he did leave, and that, from at least the documents, an argument may be made that the doctor Though, he may have felt like he was doing it at AMA. He wrote it down like it was, we're in agreement with this, and maybe you can go, pick up those scripts at the Rite Aid and, treat yourself at home and everything will be all right. So I think that's where I'd like to get to. So it's a slight variation of what you were saying on count number 8, or maybe it's an additional count number 9 on there that says and I guess it goes back to somewhat similar to a number 1. There is original failure to appreciate the sick the patient was, including whether the patient had sepsis, and that the patient would benefit from further observation in the ER. Because what I'm trying to drive at there is, that's what would potentially save this guy. And the farthest he can get with your client is keep him for observation longer in the ER in the hopes that he gets picked up for hospital admission, during the next shift or something. So,
because I don't want us in front of you to fight about the language of this. So
no, I appreciate that. And I have gotten them back
Your
to
Honor,
fight about.
With all due respect, I'm tremendously confused as to what.
Well, I'm trying to clarify.
Counsel.
Yeah, why don't you go? I'll give you the first chance, Ms. Cherry. I also see Mr. Anderson raising his finger, so I'm going to give him a chance to weigh in. This is, after all, at least a parliamentary process. I won't say democratic, but we're both parliamentary.
Thank you. Okay, so if I understand what you're saying, instead of really amending 8, plaintiff can proceed on really an amended number 1, which is failure to appreciate how sick the patient was and counsel the patient on staying for further testing.
Yes.
I'm just writing a note of that.
Okay.
Further testing.
May I ask where we're reading from, please?
Well,
I'm very confused as to what you're claiming, that counts 1 through 5, and I'm looking at the complaint 1 through 5, and it's not corresponding with what you're saying.
It's not the complaint.
What's that?
It's not the complaint. It's the testimony of your expert, Dr. Melville, on page 96 to 99. He listed 8 standard of care violations that he's alleged.
Where are we referring? What document are we referring to that's being dismissed or kept? I don't understand what we're talking about.
Sure. So we actually put it in our motion. So if you go in page 2 of our motion, paragraph 6.
Hold on just a moment, please.
Sure.
What page on your motion?
Page 2, it's paragraph 6 of our motion. And they're numbered and they're taken right from the deposition of your expert, Dr. Melville.
But you're not including the other experts that.
Well, they're not standard of care experts. There's only one standard of care expert.
I'm sorry, I thought we were talking about the non-pneumonia. Is that not the motion we're talking about?
We're talking about standard of care allegations, the non-pneumonia standard of care allegations. So that's on paragraph 6. And so it's about just standard of care claims in this case.
May I interject, Your Honor? I think my question might help this process.
Go ahead, Mr. Anderson.
Okay, so with respect to, we wrote the causation, read the cause of death motion. And if I understood your ruling correctly, you ruled that it's granted as to all of the conditions other than pneumonia. Is that correct?
That's accurate. Yeah.
Okay, so there's no other cause of death other than pneumonia that's in play.
Well, I think more accurately, sure, that because we got to attach the cause of death to the breach of the standard of care, that's where it was breached as to the pneumonia. And had he been admitted as to pneumonia, that might have fixed his problems. I guess I'm trying to work around a little bit of a legal conundrum presented by the malpractice statute. And obviously, you have to have a cause of death, and I think the cases are quite clear in that you do need to do that. However, and we also, conveniently have a cause of death of pneumonia, at least testified to by one expert, so the jury could, arguably say, you know what, they put down pneumonia on this. The doc had a basis for it, so let's proceed right through on the standard of care regarding pneumonia. And that he should have been observed longer. And it's not just pneumonia. They should have worried about this other stuff too. But at least Mr. Dibb has provided a straight line with regarding the pneumonia claim.
So
Sure.
that motion should be
and with
denied. Hold on a second, please. That motion should be denied then if you're allowing the immediate cause of death to be pneumonia and the other factors to be contributing factors.
Yeah, I'm not going to say contributing to the cause of death. I'm going to say there are additional evidentiary factors that ought to have been considered in the
Okay.
decision making regarding this patient. But I think I'm going to grant it in part and deny it in part. And the portion that is denied is that I'm going to allow you to proceed with the cause of death. I'm going to say that, there was a diagnosis of pneumonia. There's certainly a good argument that he should have been observed to treat pneumonia, and that, and part of that is the evidence of the other conditions. And finally, we do have an expert that's going to testify, that more likely than not, he died of pneumonia after he went home. So I think that it can persist on those claims.
Okay. And then
Does that then resolve the motion that Ms. Cherry was talking?
So that's my question. So just administratively, Your Honor, because that ruling with the causation motion ties into the breach motion of the co-defendant, are you asking her to do that or to incorporate the causation motion in her order as well?
Yes, I am.
Okay, because we wrote it, so I just wanted to clarify it's not our responsibility to.
Yeah, I think she joined in it, right. So hopefully, I guess
yes.
what I'm trying to do is get to, and I realize this is litigation in an adversary system, but as clear, cause of action as we can get to, that ultimately, would be presented to a jury, so that a jury could say, okay, I can understand the questions you're asking me to decide. That's what I'm trying to do. So.
Got it. I just wanted to make sure I didn't not submit an order you wanted me to submit. We just got the Menzies order, and I'm clear on that now.
That's what I would do if I were in your seat, Mr. Anderson.
Yep.
I would just get out and wish the remaining lawyers the best of luck going forward. So
sounds good. Sounds good.
So then,
All
if
right,
I understand what you said, Your Honor, and I apologize.
Yeah, no,
I
that's fine.
prefer to
Yeah.
deal with it now instead of coming back and dealing with it.
I understand.
So it sounds like, based on your ruling, the cause of death, granted in part, denied in part, permitted to proceed on cause of death and pneumonia. And then that leaves, as to my motion regarding standard of care, that plaintiff is permitted to proceed on standard of care allegations as it relates to failure to counsel patient to stay for further testing for pneumonia. And then numbers 6 and 7, 6 being failure to administer IV antibiotics for pneumonia, 7 being failure to evaluate the patient for Legionnaires' pneumonia. Is that correct?
The only thing I would
wait.
broaden a little bit is that what you said on number 1 is failure to counsel the patient to remain for further testing, period. Because, any doc's, he's not going to look solely at pneumonia. Of course, even in the decision as to whether or not to administer antibiotics, he's got to consider that whole universe of other conditions and figure out where the patient stands. So I think it wouldn't be fair to say, we're only gonna keep you and treat pneumonia at this point, even though you gotta, in reality, when you're admitted to the hospital, the docs are considering, and the situation here includes, all these other life-threatening medical conditions that the guy has, even though, the argument's going to be here. It's the pneumonia that got him in the end. So, I think.
But Your Honor,
sure
I just want to clarify, and I'm using Ms. Cherry's paragraph number 6 in your motion as a reference point. As you indicated in response to the causation decision that you were going to, that your ruling is that plaintiff may proceed on pneumonia as the cause of death, and that these other factors should have been observed, as if I wrote down your statement accurately.
Admission
that these
for
other
continued
factors,
observation and testing.
and that would include these other factors that Ms. Cherry has in her paragraph 6, that is to appreciate how sick the patient was, including whether he had sepsis, the failure to recognize the hemoptysis, failure to work up chest pain, failure to work up tachycardia, failure to work up acute kidney injury, failure to administer IV antibiotics, and failure to evaluate the patient for Legionella, and
Well,
failure
I'm
to
not going to keep
indicate
all
the
those in there
medical.
because then it sounds like I think all those were the cause of death, and I don't. The only one I can think is the cause of death is the pneumonia because that's what we got on your argument. Your expert's going to say we should have put on the death certificate, and that I think the testimony is going to come around. At the end of the day, even starts conclusion there. Well, it's a pretty broad one. Arguably his cause of death, includes all of the above, various conditions that were, argued by you. But what I would like to do is present it to the jury in a way that they can see, okay, came in, diagnosis of pneumonia, continued observation, and treatment for pneumonia, including potential antibiotics in the ER and continuing monitoring for these other, monitoring and testing additional medical conditions that were present. But, we're not going to make the argument those were the cause of death because we're stuck with pneumonia. So, uh, that's where
I think that's
would
what
like
I,
to.
that's what I was trying to get at, that you are allowing the plaintiff to keep the claim that he should have been kept and followed for all of these other I don't want to go through the whole litany.
Yeah, no,
But
and I
Well,
think the
well,
reason
I,
I think, yeah, the other ones are relevant is because this isn't solely a pneumonia guy. This is a sick guy whose worst,
right,
or first diagnosis is pneumonia. But
right.
nonetheless, of course, everyone's going to know the doctors pay attention to that other stuff too.
Okay.
well, Your Honor, then that would then go against your ruling. So plaintiff's counsel is trying to backtrack your entire ruling and say, oh,
No,
wait, we
that's
can
not.
talk about
No, no.
claims
Well, here's
one
what
through
the way I
five.
think we get around that, Miss Cherry, is that I'm limiting his argument as to the cause of death being pneumonia. Now, the other
Right,
things are out there; they're operating in the background.
right.
Should they have been treated or addressed, and might they have been even in the treatment of the pneumonia? Maybe, but at the end of the day, um, you know the uh, the ultimate cause of death is stated, testified by an expert, and plaintiff's expert, and in his light is he's going to have to argue, no, that was pneumonia. And I think that's fair. And the others don't come in. They're not testifying, boy, these other things probably killed him or might have killed him. I guess, they can say those are life-threatening conditions, but at the end of the day, we do have an expert that says he believes the pneumonia was the cause. That's enough to get it to the jury. They can think about the other things in terms of weighing them, in terms of that decision to retain him for further observation, but they're not going to weigh those in terms of the potential cause of death.
Okay,
So
so to
how
make
we
sure
might
that,
get that
again,
on a verdict form, I have no idea, but
that's
we're not there yet.
That's okay. So to make sure that we're not back here fighting, the plaintiff can proceed only on standard of care claims. You've amended number one to say failure to counsel patient remain for further observation testing, and then only number 6 and 7, correct?
No, that's not what the court said.
That is
Yep.
exactly what the court
No,
said, and that's why I wanted to clarify.
Well,
no,
he has the number one I read here was failure to appreciate how sick the
right,
patient was and
correct.
counsel the patient on, the importance of remaining for further observation.
And the other things that are contained in her number 6, I think what the court is saying is
No,
that the plaintiff's experts may testify that the ultimate cause of death was pneumonia, and that it was a breach of the standard of care for them not to have continued observation for all of these other conditions for which he should have been admitted. I think that's what the court is saying here, isn't it?
that's not my understanding, because Your Honor, if you
That's
let
clearly
in
my understanding.
so then it goes back to the crux of my claim. If you permit plaintiff to talk about the failure to appreciate how sick the patient was, including the patient had sepsis, failure
Right.
to recognize hemoptysis, failure to
These are
work
all
up chest
life-threatening
pain,
conditions. These are all,
excuse me, Mr. Dibb,
but I mean,
failure
the
to
court
work up a
already said
patient
that
for
these were
tachycardia.
life-threatening
Your
conditions.
Honor, can I
Well,
speak?
hang on just for a sec here. Yeah, I get what both sides are saying, and I think what I'm hearing Ms. Cherry say is, well, if Mr. Dibb comes in and argues that these were all present and potentially life-threatening, well, it's more or less the equivalent of saying, any of those could have been what killed him, folks. You take a guess at it.
But that's the
you know,
testimony, Your Honor. That's what the experts have said,
No,
that
that's
all of
not what
these.
we've been talking about for
well,
the last
and
hour
the
and a half.
problem is we can't let the jury make a wild guess like that. You know, they have to come to some conclusion that the cause of death was something that the diagnosis and treatment would have prevented and thus violated the standard of care. And that's why I'm hinging on the pneumonia. Now, I'm not saying they couldn't have considered and that shouldn't have considered those things, but I'm saying at the end of the day, you know, the cause of death testimony that I'll take won't be the guesses at it, but rather, you know, the one doc that'll say, you know, I would have put pneumonia on the death certificate, and that's what we'll go forward with. And the other docs may talk about the presence and the seriousness of those conditions, but they may not say they're, you know, allowed to guess at the cause of death. I'm just not going to allow speculation to go in front of the jury there. The jury's going to have to
I
somehow say,
understand that. I understand that completely.
Well, but that's the cause of death issue. And so to clarify, because if not, I'm going to file an order on this case and Mr. Dibb's going to file an objection and we'll be right back here arguing the same thing.
well,
And
I
so as it
can't say
relates to
that's never happened before.
but as it relates to standard of care allegations that will proceed against Affman connected to pneumonia, I just want to make sure my order is going to say our motion is granted in part and the plaintiff can only proceed on standard of care claims. Number one, failure to appreciate how sick the patient was and remain for further observation testing. Number two, failure to administer IV antibiotics for pneumonia. And number three, failure to evaluate patient for Legionnaires' pneumonia. That's it. Is that correct, Your Honor?
No, that's not the court's decision.
Yeah, no, well, that is, I think that sums it up because then
Thank
your
you.
rest of your evidence comes in under the number one where you're saying, you know, not only are we admitting them from pneumonia, but we're obviously observing, you know, a million other conditions that are problematic as well.
Exactly. And it was a breach. And the claim is that it was a breach of the standard of care not to admit him to observe these other conditions.
Yeah, and I think that's really what it comes down to is right.
Correct.
I mean, we're not going to say admit him because no one here can admit him, but rather to continue to observe him,
So
hoping
continue
someone
to
else will
observe
admit
him for all these other conditions. But Ms. Cherry wants to exclude all these other conditions, which you can't start redacting the medical record to exclude how sick this patient was, given the significance of his illness when he presented. That, by the way, is documented objectively. It's not, none of his conditions were subjective determinations. They were
No,
all
right.
objective.
All by testing and stuff
All
like
by
that.
testing and
Yeah.
X-ray. Yeah, I mean, the X-ray showed he had cardiomegaly. The lab test showed that he had all of these other conditions, the hypokalemia, the kidney failure. So
Your Honor, all he's doing is trying to walk back your ruling, which I've already clarified.
excuse me, counsel, please.
No. Well, I guess what
All-
I am trying, I understand, Mr. Dibb, what you're saying, and I agree, objectively looking at this guy's chart. He's a very sick guy, a lot of problems. I think the jury should know about that, because that impacts, of course, the doctor's decision-making process. And I think ultimately here, you know, they're evaluating, you know, first, you know, should the doctor have made some stronger case to the guy for continuing an observation? And then second, you know, even maybe if the doctor made his strongest case or, you know, did the best he could, the guy would have walked out anyways. And I mean, those are not, in the end of the day, you know, those are fact questions, but not directly. You can do the best standard of care ever, and if the guy won't stay and you know, accept the treatment, you know, the standard of care is pretty irrelevant.
I understand your decision now, and I just want to make sure that the order, whatever council drafts, is reflective of what you just stated, Your Honor.
Right.
Well,
Well, why don't we give a stab at it as we currently stand? I'll let Ms. Cherry ask any additional questions that she has, and then I'll let her give a stab at it. And we have to reconcile it down the road. We can do that, although I can tell you this stuff is as fresh in my mind right now as it's going to be. And if I look at it in 2 weeks, it'll look to me like I'm, you know, trying to discern how many rings are around Saturn or something like that. So, Ms. Cherry, did you have any more questions?
Yes, Your Honor, because every time Mr. Dibbs says something, he seems to try to be undoing your ruling. And so your ruling, because you've already ruled on the cause of death issue, the only standard of care allegations that will proceed in this case are number one, failure to appreciate how sick the patient was and counsel patient to remain in the emergency department and hospital for further observation testing. Number two, failure to administer IV antibiotics for pneumonia. And number three, failure to evaluate the patient for Legionnaire's pneumonia. All other standard of care claims are dismissed with prejudice. Is
No,
that
that's not.
correct? That's
That's
exactly
not what
what
the
No,
court-
let me, I can clarify that one.
That's
That-
not what the
No,
court.
I think what Ms. Sherry is saying is correct, regarding the standard of care claims. However, inside that failure to appreciate how sick he is, there's a lot of room to argue about how much of that evidence ought to be and should be heard by the jury, because again, that impacts the doc's decision-making process on retention, in the ER writ largely. So I think that will allow both sides to present a reasonable case. Why don't you submit the order as you stated, Ms. Cherry? If Mr. Dibb disagrees with it, we can take additional briefing and I can review what I did today. But, as we sit here today, I think we've got it pretty close anyway to where I want it to be following my decision. So.
Thank you, Your Honor.
Thank
All
you, Your
right.
Honor.
In order. Thank you.
Thank you all. Very well
By the
briefed
way,
and
by the
well
way,
argued.
Your Honor, the answer is 7.
7. The answer is always 7. Oh, the rings of Saturn.
Yes. Right. I remember
I'm
that from
glad you know
elementary
that,
school.
Mr. Dibb.
I just remember that from 5th grade.
If I learned it at one time, I have since forgot it, along with a lot of information.
Thank you, Your Honor.
Thank you all.
Thank you, Your Honor. Have a great
Thank
weekend.
you.
You as well.
Bye-bye.